Hello and welcome to another episode of Jinnah Institute's podcast series. Today we'll be continuing our conversation on how religious minorities in Pakistan face marginalization and also looking at the various hurdles they face in multiple spheres. While issues such as the weaponization of the blasphemy law, instances of mob violence are rightly highlighted in the mainstream, there is little attention paid to the other hurdles faced by these members of the community when they require interaction with the state. Our focus today will be particularly on matrimonial law and how members of these communities are deprived of their fundamental rights as the legal system is ill-equipped to adjudicate on cases of divorce. To discuss this very important issue with us, we have Mashal Gilani, who is a senior research associate at the Legal Aid Society. Thank you so much for joining us today.
No worries.
If we could start with your ongoing research, I believe it is focused on the Christian community members, particularly in Sindh. If you could please enlighten our audiences about the nature of the issue that's being faced by them, particularly with regards to divorce cases.
Yeah, sure. So as you rightly said, my research is based on Christian community and other religiously marginalized communities within Sindh, particularly in 8 districts across Sindh, including Karachi. And we focus on a range of issues, but especially family law and divorce law. Divorce specifically concerning Christian divorce because as the law currently stands, Christians currently do have very limited grounds to get a divorce. The primary one being abuse or adultery, an allegation of that, and the need to prove that in court. So as it is plainly understandable that these limited grounds do cause some hardships to the community, because first of all, again, if a marriage breaks down or if the parties require a no-fault divorce, which is where both the parties agree that the marriage cannot continue, that they do not wish to live together, the only option that is available to them is a judicial separation, which is not as strong as a divorce,
Right.
which is not legally considered the end of a marriage. So again, this means that the Christian community is very limited in how it seeks a legal divorce, on how possibly they can move on from the end of a marriage. And I think that also causes some lack of dignity to the woman, especially because then she is in open court, often accused of adultery by the man,
Right.
who requires a divorce. And even if the divorce is not granted on some other grounds, her dignity is questioned in an open court. And it is very hard for her to move on from that. So I think it causes multiple challenges. One being having limited access to legal divorce or a legal end to a marriage. And the second being that questioning about the dignity of a woman. And that is all assuming that the judiciary and the lawyers who are presenting the case have an idea about what the grounds of divorce are, how to proceed with a divorce for religiously marginalized community, how it is different from Muslim communities, because that's the baseline for a lot of our justice sector. So yeah, that is particularly what we're focusing on.
Right. Thank you for setting that background. If I think what you were just referring to, the requirement to prove adultery or abuse, you're referring to Section 10. If you could please speak more about the background of this law and its evolution.
Okay. So in the entirety of Pakistan, we currently follow the Christian Divorce Act, which is an 1860s law. It was brought by, as the timepiece suggests, by the British rule. Again, during that time, we didn't have a lot of Christians, but there were conversions, and the Christian community was growing. So the British thought it was fit to introduce a British law. Now, this law has, since the British rule, gone through some changes, not entirely, but Section 10, as you rightly pointed out, mentions the grounds under which a man and a woman can seek divorce, a Christian man and a woman can seek divorce. So the grounds for a Christian man to seek divorce are, again, alleging and proving adultery. The grounds for a Christian woman are somewhat more than the Christian man. She can claim that the man converted to another religion, adultery, abuse, violence, and her being unhappy in a marriage. But that all has to be proved under a very rigorous it's like
Very
it's
hard to
it's
make the
scrutinized
case.
under a
Right.
very like harsh eye. So again, that means that by default, a lot of what and a lot of our precedents that is present, a lot of the judgments that are present, and this is excluding Punjab, and we'll get to that later. But excluding Punjab, a lot of the precedent that's based on is around adultery. So by default, a lot of the Christian community just moves to adultery as a way to end their marriage legally, and not go back to a judicial separation. So, besides Section 10, we also had a Section 7 in the Act, which said that in case of changes, the Pakistani court system would follow the British court system. Now, this particular section was removed under Zia, so we had a nationwide removal of certain sections of certain acts, and this particularly affected the Christian community.
Right.
So, Section 7 of the Christian Divorce Act, which said that in default of an evolution within the Christian law in Pakistan, the Pakistani courts can move towards laws that are followed by the British courts. Now, this was helpful because before the removal of this particular section in 1981, courts could rely on Section 7 of the English Matrimonial Act, which meant that Section 7 of the Act allowed for a no-fault divorce, which means that a divorce on mutual consent, that both parties do want to end the marriage. Since 1981, parties have not been able to rely on that. And so again, that dignified option of ending a marriage has been taken away from that. So I also mentioned that Punjab does not follow this. This is particularly because of a judgment that came out in 2017. So Syed Mansoor Ali Shah, who was the Chief Justice of Punjab at that time and is now a justice on the Supreme Court of Pakistan, gave a very landmark judgment. It's called the Amin Masih judgment, which says that, and the plaintiff in that case relied on multiple international conventions that Pakistan is a party to, relied on Section 7, which had been removed from the Christian Divorce Act. And he argued that the marriage had simply broken down. The parties did not wish to live together, and he did not want to accuse his wife of adultery simply to get a divorce.
Right.
Which again sounds all very reasonable, right? That he does not want to falsely accuse someone of adultery. So the justice heard the case, and they decided, based on the international conventions, based on why that particular section was removed, and they decided that section 7 is to be restored. It is to be read in conjunction with Section 10 of the Christian Divorce Act, and that a divorce based on mutual consent is possible and is completely legal. Because it allows for the evolution of law, allows for a justified evolution from the law, because again, the law that we currently have is 150 years old.
Right.
So it is needed that law evolves, and that law also evolves according to international standards, because besides the international conventions, a lot of international community have adopted a no-fault divorce. Even in Pakistan, we have the concept of a no-fault divorce. It's just that wasn't applicable to Christians. So now we do have that. But in Punjab.
Right. No, it definitely speaks volumes regarding the state's neglect. The fact that it took till 2017 for this, landmark judgment to take place. But as your ongoing study points out, this is still an issue in Sindh. If you could please speak more about that, and why, what the factors are that are still perpetuating this issue.
Yeah, so this is an issue in Sindh and also other provinces of Pakistan besides Punjab. But since my research pertains to Sindh, I'll speak mostly on that, since I have more knowledge of that. So currently what we do is that we take on legal cases from religiously marginalized communities, and we are also conducting a knowledge, attitude, and practices survey with members of the justice sector within Sindh. So our research is kind of influenced by the justice sector and their attitudes towards the communities, and also the community's attitudes towards the justice sector, and how the community feels when they go to the justice system, how their cases proceed. So upon a perusal of case files, previously decided case files, upon looking at the cases that we taken, and upon seeing how judges reacted to problems of the Christian community, we saw that a lot of the judges and a lot of the lawyers do not have an understanding of what the law is, or an awareness of what the law is. They simply do not know what, so they know that, for example, there is a Christian Divorce Act, but what provision of it applies, what is the procedure to be followed, how you can bring in the Amin Masih judgment as persuasive precedent, and how you can argue that since it is a High Court judgment, not the High Court judgment of the particular province, but it's still highly persuasive since it is the Lahore High Court's judgment. Right. And how to argue that, what sections to apply, what arguments to make. So again, this could be because a lot of our cases that we do take in, or a lot of the communities that we did question, were from a lower socioeconomic background, so they could not afford good lawyers. But that again should not be a hindrance towards justice, right? Yeah. But then if a community is, or if a plaintiff is from a lower socioeconomic class, then the onus should fall on the judge in the particular case to know about the law, to question the lawyers about the law, to advise them to look into that law. But then when we go to the judges themselves do not know what the law is. The judges do not even know of the landmark judgment from Lahore. They do not know what the act is, or what how to interpret that act. So again, it just falls back into a lack of knowledge from the justice sector, the entirety of the justice sector, be it the lawyers, be it the judges, or even the court staff. So when you do go to register the case, it's often a question about what act or what section it would be registered in, because the court staff also does not know what sections to follow or what acts to follow. So it boils down to a very simple thing, that we just follow a very streamlined process, but a streamlined process that is kind of suited to the Muslim community, because we just accept that since the majority of the population follows that, right, that is going to be the default for everyone. So we do not open our eyes, or we don't try to see what other laws there exist, what are the communities that there exist, and how we can benefit them.
I think वो precedents की भी जो बात आपने की थी, it goes back to the same thing, कि since it's an Islamic majority country, so most of the precedents also pertain to Islamic family law.
Yes. Right. So it does pertain to Islamic family law. And when you do have Christian precedents, like for example, we have seen judgments within Sindh where majorly even the Amin Masih judgment is not cited, but that is a far-fetched idea. If the lawyers cite the correct section even, it's very rarely that they will be given a decision in their favor, or they will be granted a divorce, because again, it just boils down to very minuscule ideas of what adultery is or what cruelty is. But where the Amin Masih judgment is cited as a ground for mutual divorce under mutual consent, judges often have to be taught about what it is, often have to be enlightened about what it is. And when that is the case, we've seen that it is more likely that you will be granted a divorce. So again, when you do get precedents, yes, a majority of them are based on Muslim law, but the few that you have on Christian law, if they are properly cited, if they are properly used in your arguments, it is possible to get a judgment in your favor. But then again, it comes back to knowledge. Do you have the knowledge, or do you have an idea that this judgment exists that you can cite? Or even if that is not the case, even if you don't want to cite a Lahore judgment or a Punjab judgment, there are multiple district court judgments within Sindh that have kind of followed the same idea as the Amin Masih judgment, kind of have restored Section 7. Again, a district court is a lower court, so you can't really say that it's binding, because district courts can overrule themselves. But again, could be used as highly persuasive, especially since it is within the same province.
Right. Yeah, I think that and I know this is ongoing research, but there were some very interesting stats also on the impact of using the correct provision.
Yes. So again, it was more likely than not that you would if you would use the correct provisions and or if you cited a similar law or similar precedent, that you would get a judgment in your favor. So it's just all about knowledge. Like, there is a dearth of knowledge within the justice sector. There is a evident knowledge gap, and if that knowledge gap was to be filled, then it would really help the community, again, and not just getting a divorce, but in other aspects of family law itself. Again, that is also covered by the Christian Divorce Act, that, for example, maintenance after getting a divorce, or maintenance throughout the process of the divorce. So again, if you were to see Muslims, because since the justice sector assumes them as a default, like, let's just look at the system, right, for Muslims. So for Muslims, what the scenario is that after divorce, after not a judicial separation, after divorce, Muslim women are not entitled to maintenance. So that is assumed to be the same for every community within Pakistan, especially within Sindh.
Right.
But that is not the case. If we were to look at Christian communities, Christian women after divorce are entitled to alimony. It's 1/5 of the husband's earnings. And that is till the woman remarries. So since Muslim women are not entitled to maintenance, we also saw that Christian women often did not claim maintenance. The same is for Hindu women. Hindu women, yes, there is some hurdles to how they can get maintenance, especially since the 2018 Act. If a woman leaves her house by herself, she is not entirely entitled to maintenance. But if she does get a divorce on some other ground, she is entitled to maintenance. But then again, they don't claim maintenance. And we, in our research, we assume that this was due to multiple reasons, the primary being that people did not know that Hindu women or Christian women can claim maintenance. This is actually proven by our other research that we did, the gap analysis with the justice sector, where we had explicitly asked them a question about whether Hindu women can claim maintenance after divorce. And the answers were kind of shocking, but not that surprising, that they cannot. The answers mainly said that they cannot claim maintenance, but that is not true. They can claim maintenance after a divorce. So again, it comes back to the same thing, that you just assume that the same law applies to everyone, and that law is the Muslim law.
Right.
So yeah.
Right. If we could now talk a little bit about the 2019 marriage law bill, and also the consultative process, and the issues along the way, and why that didn't go through. If we could speak a little more to that, and what takeaways there were.
Okay, yeah. So the 2019 Act that bill that you're citing is the Christian Marriage and Divorce Bill of 2019 that Shireen Mazari actually tried to bring about. So there are a few caveats with this. The first one is that since a lot of detail was not disclosed around the bill, there were independent articles and there were independent consultants who did come forward with what actually happened and how they were approached. So we can talk about those things. But since the government did not really put out a statement on what happened, we can't completely know for sure what happened. A lot of it is assumptions. And the second is that since the bill was also not published, we don't know completely what the provisions were. But as we understand it, there were multiple changes that were to be brought about. Firstly, the 150-year-old Christian Marriage Act and the Christian Divorce Act were presumably to be replaced by the new 2019 bill, which would replace the definition of a Christian, because again, we have 3 different churches in Pakistan. The Catholic Church, the Church of Pakistan, and the Protestant Church. And while they do kind of have majorly similar ideas about who a Christian is, they just sought to remove the definition of a Christian. So how that would help would be that it would not be limited to a particular community, or it would not be limited to a particular section within a community. Anyone who wishes to utilize the act could utilize the act. Anyone who wishes to not utilize the act could not. So
there's that flexibility.
Yes, so that is a good thing, because, for example, the Catholic Church does not accept divorce, right? They do not acknowledge divorce as a ground for ending the marriage. So then those particular sections would simply not apply to them. because they would not fall under the definition of the act for those particular sections, but they would, but the how a marriage is to be conducted or how a marriage is to be solemnized and registered would apply to them. So it would be very convenience based, and it would apply to a majority of the population instead of singling out a single section within the community.
Right.
Yeah. So the second thing that they sought to do was bring statutory footing to the Amin Masih judgment, which is used by a majority of the Christian population. So since, again, it is a particular High Court's judgment, it could at any time be overruled, or it could not be applied in other provinces. So instead of that unreliability of the judgment, they sought to bring about a federal law that would apply to everyone, and that could not be questioned in courts, because if it has statutory footing, then it would need to apply to every case. So you would have the no-fault divorce as a ground for divorce under a federal law. Again, a big win. But the drawbacks of that were that, as I understand it, that again, it fell onto parliamentarians that were Christians. But we have to understand that even parliamentarians or representatives who are selected from the community are not necessarily selected on the basis of their based on the religion, or them being religious leaders, or them being acceptable
representative leaders.
Yes, representative leaders within the community. A lot of times it is how much work you've done for the party, or how much work you've done for a particular government. So when it did fall into the shoulders of the Christian parliamentarians, most of them were not either social activists or lawyers or people who had knowledge of the ground realities of the community. These representatives also often come from a higher socioeconomic background, which is not true for a lot of the community. So again, not accurate representatives of the community. So when they were consulted, a lot of them also spoke up and admitted that they're not accurate representatives, or are religious leaders even, who can comment on it. So then the question was whether this is a civil law that is to be enacted by the parliament, or is it a religious law that needs religious leaders to comment on it. So then that question got brought up, and it was decided, no, that this is a civil law. This is the law that governs the citizens of the country. It does not seek to amend any religious provisions. Every religious community will still be entitled to their own religious customs, own religious laws. But this is just an overarching civil law that seeks to just harmonize all the laws for the Christian citizens of the community. So that question was answered.
I think, sorry to interject, but I think the Amin Masih judgment also relied on the same interpretation. Okay, civil law, and they're not looking to interpret or reinterpret the Bible in this case.
Yes, exactly, right? Because then when you do seek to do that, or when you claim to do that, then you have to be an expert in the field. But you're not doing that. The Amin Masih judgment heavily, which is why it heavily relied on international conventions, and that Pakistan is a signatory to, like the United Nations Declaration for Human Rights, the ICCPR, and especially the right to religious freedom and the right to dignity of women. It's specifically relied on the right to dignity of women and the right to equality under the law, because women, it took the point of
gendered aspect of this, of course.
So they took the point of view that women were being discriminated, which is why we're creating this judgment. And while that is a very safe aspect of it, and a very safe point of view, it is also, in my opinion, the correct point of view, because then you do not mess with the religious customs and do not upset anyone's religious beliefs in going about that. You just look at how women are being affected under it, and how the law should be equal for men and women, and women of all religions. So yeah, I think the Amin Masih judgment and the 2019 bill both looked at it from that point of view, just to safeguard themselves, but also the religious sentiments of the community.
Right. That was very helpful context. I think it remains to be seen how far away we are from having federal law when it comes to this. But in terms of recommendations, I know we were having a conversation about this, and he said that it's hard to even like specify recommendations because there are so many caveats. But if we were to talk about recommendations or solutions, specifically based on your research in Sindh, if you could speak to that a bit.
Yeah, so again, yes, there are a lot of caveats that go with recommendations, because while we like to claim that these should be the recommendations, we also have to understand that they have to be reasonable and reasonably available to everyone.
Right.
So yes, it could be as easy as placing a copy of the Hindu Marriage and Divorce Act, Christian Divorce Act, Christian Marriage Act within the courts. Whether that be in Sindh or any other province within Pakistan, so that judges have access to it. It could involve trainings for the judiciary, trainings for lawyers. Again, these I understand are judges, yes, could be a duty on the government, whether provincial or federal, but a duty to train the lawyers would fall on the civil society, on NGOs particularly, whether they want to take this up and they want to train lawyers on how to approach cases of divorce, whether Christians or Hindus, and how the laws for the communities differ from the laws for Muslims, and what other rights do these communities have that Muslims may not have, or how they differ, or something like that. But then again, the onus falls on civil society, and we can't really ask them to do this because it is the government's job to do this. And I think the government should introduce trainings either at the federal level or a provincial level for judges to know what the laws are. Other recommendations could be that we should reinstate Section 7 of the Christian Divorce Act, which would be faster and which would provide relief for the time period till when it is reinstated, till when the government does decide to bring about a federal law. During that time period, the community would have a recourse or a relief to that act, and they could access the English Act. Again, reinstating Section 7 brings about the question of why should Pakistan as an independent country follow the law of the British and follow the law of England or some other country. But then while
as a stopgap measure.
Yes, while Pakistan creates their own law that actually gives rights to everyone, maybe we can have access to that, and
till we come up with something more comprehensive. Right. No, that makes complete sense. Thank you so much for taking the time out to discuss this very important issue with us. If you enjoyed this conversation and found it interesting, please subscribe to our channel so that you can stay up to date with our upcoming webinars and podcasts. Thank you once again.